McEwan versus State of Florida. All right, let's do it.
May it please the court, counsel. Your Honors, this is an appeal from a 3850. This is an ineffective assistance of counsel matter here in Hillsborough County. Mr. McEwan was complaining about his attorney's performance at a couple of hearings, including his trial. And while questioning one of the witnesses that was presented at his 3850 hearing, Mr. McEwan became upset with his current appointed counsel. During a break, the appointed counsel approaches the judge presiding, who is not normally a 3850 judge.
Can I back you up just a minute?
Sure.
I think that the gist of this is there's a complaint that that Witness Rhys should have been called at the motion for new trial.
Correct, Your Honor.
What makes anyone think that Witness Rhys would have said anything different at that hearing than he said at the trial?
I don't have a good answer for that, Your Honor.
Isn't that kind of a problem?
It is, and it is.
In fact, when Rees was called at the 3850 hearing, he said, "I wasn't going to recant my testimony. I wasn't going to come into court and say that I lied in trial."
Correct.
So how can you ever prevail on an ineffective assistance when the underlying premise is that Witness Rhys was somehow going to recant his testimony where he clearly was not going to do that?
Well, it was a slightly different situation at the motion for new trial. First off, I'm not sure the motion for new trial, in all candor to the court, should have gone forward. The judge hearing it was asked to take the motion under a provision of the motion for new trial rule that I don't know that it allows it to do that. But moving past that, the judge did hear it. At that point, the counsel presented 4 women who were at the party, because this is a robbery/shooting that happened at a birthday party, I believe, out in Plant City. And these 4 women, a few weeks after this incident, confronted Mr. Rees, and Mr. Rees basically, in their eyes, in the 4 witnesses' eyes, recanted what he was going to say.
Yes, but Rees was called at the 3850 and said that never happened.
But he was not confronted.
So you're not going to get a new trial based on impeaching Rees. Rees would have had to come in and say, you know what, I've had a pang of conscience, I'm changing my testimony, I lied at trial. He didn't say any of those things or anything of the sort. He said, this what these ladies are saying never happened.
That's correct. But yes, that is correct, Your Honor, and then it boils down to
the cross-examination by Mr. Diaz at the 3850 starts off and says, Mr. Rees, the central issue here is the defendant's claim that if you had been called at the motion for new trial, you would have testified at the motion that you admitted to having lied about Mr. McEwan. Did you at trial lie about Mr. McEwan about the actions that he committed? Answer, in no shape, form, or fashion, no. Doesn't that end it?
That ends that? Yes, that does end it, because now it becomes an issue for the court to determine credibility, and it hasn't had his credibility sufficiently impeached at that point. But that wasn't the issue that the issue.
Well, I understand you're now complaining about the lack of a Nelson hearing, although it looks like an adequate Nelson hearing was in fact conducted. But the premise behind that is that somehow Rees would have said something if what your client asked for during the Nelson hearing is he said, I want to ask some questions. We don't really know what he wanted to ask or why or what that would have done or anything of the sort. What we do know is that Rees said over and over again on direct and on cross, I'm not changing my testimony. There's no reason to call me at a motion for new hearing. I testified at trial, I said what I said, ball game. That's where I'm
well,
and as you know, I heard a lot of these.
Well, when we're dealing with Nelson, and we're also dealing with Faretta, we're dealing with the Sixth Amendment, Your Honor. And as this court well knows, that the United States Supreme Court has pointed out that regardless of the outcome of the trial.
Well, there's nothing in the transcript indicating he wanted a Faretta hearing or wanted to fire his lawyers. There's nothing like that. There's nothing in the transcript saying he wanted to testify.
Well, but there is, Your Honor.
Show me.
When Ms. Murray approaches the Judge Barbas, and says he would like a Nelson hearing, that
right.
triggers an entire colloquy. Now, the form, different districts have
So
said
then
there's...
Judge Barbas takes him through all the...
Correct.
What is it that you want to do? What's the problem here?
And-
What's going on? And he said, well, I want to ask some questions. But the point is that I don't know how he's going to get blood from a turnip by him asking questions of Rees that have already been asked by his lawyer.
But understanding your point, the third part of a Nelson colloquy is yes, I have, as a judge, I have found that your attorney is not ineffective. Do you want to represent yourself? That's part of a Nelson inquiry. That never happened. So if we're going to have a Nelson hearing, if we're going to have a Nelson standard for the state, which says, I'm going to ask you about, Mr. Defendant, I'm going to ask you about what your problem is with your attorney. And then I'm going to move from that to whether I determine that is ineffective or deficient in some fashion, yes or no. If I determine no, then the next step is, sir, I've appointed you counsel. You are dissatisfied with your counsel. Do you want to represent yourself? That's the next step. It was never done. It was never done, and that makes it inadequate under the Nelson umbrella of all the cases in this state, regardless of whether or not he could prevail at the 3850 hearing.
Your opponent will address the adequacy of the Nelson hearing. It doesn't necessarily have to go step by step. There was a discussion there, and he'll, I'm sure, address the adequacy of it. So.
But, Your Honor, I would say I understand the court's point, but I think that had they moved on to the Faretta hearing, he was asking, can I ask questions? And the Florida Supreme Court has basically said you can't have, in that Logan case, you can't have hybrid representation. You either are appointed counsel or you're not appointed counsel. So, but if that's where we are, I would reserve the rest of my time for rebuttal.
Okay, you want 5 minutes if you need it? I'll give you that for rebuttal, okay.
If I need it, Your Honor.
All right. State?
Morning. May it please the court, counsel. As you're talking about, Your Honor, that Rees did testify at the 3850 hearing, and he said the same thing he would have said at the motion for new trial, the same thing he testified at the trial, that this was the truth. This is exactly what he would have stated, and it would have stated the same thing at the new trial. So I wouldn't even get to a point of ineffective assistance of counsel here. And
I think his main complaint is the adequacy of the Nelson hearing.
Yes.
And what's the standard of review as to whether or not the trial court did an adequate job in the Nelson hearing?
Well, as counsel had pointed out, said that the constitutional rights somehow attach in a post-conviction, but that's not the case. Fifth and Sixth
Well, there was
Amendment.
a clear request for a Nelson hearing, and then there was a discussion by Judge Barbas. Did that meet the standard, or did it not?
It absolutely met the standard for post-conviction because nothing really triggers a full Nelson Faretta hearing in a post-conviction hearing, and this is what we have here. It basically came down even to trial strategy, Your Honor. We had the defendant basically say, hey, I want to ask this particular witness questions if my attorney doesn't wish to answer these questions, ask these questions to the witness.
We don't know what the questions were. So would that come under the umbrella of a generalized complaint? Anything specific about that statement?
It would have been a generalized complaint because, I mean...
And the standard of whether or not the hearing is adequate is an abuse of discretion?
That's correct, Your Honor.
So can you point to anything that would show the court abused its discretion by not going into more detail than it did?
Absolutely not, Your Honor. It was within the trial court's discretion to not even really ask for not even conduct the Faretta hearing or the Nelson hearing. And just for caution, it was basically within the rubric of Faretta, within the rubric of Nelson, and just asked the defendant what was the problem. And the problem was trial strategy, and you're not entitled to get counsel on trial strategy. So the court doesn't have any further questions. We ask that you deny appellant's request for a new hearing. Thank you.
Mr. Candela?
Thank you. Just 2 points before I ask you to reverse and remand this for a new hearing. I think the state's misstating something. The McGirth case, which is cited in my brief, is the Florida Supreme Court's statement on this. There are Nelson, and then by extension of Nelson, Faretta implications for post-conviction matters. So if that's the law in 2017, then that has to control. And then if that's the case in a 3850 hearing, in a Rule 3850 hearing, that means that all those provisions have to be followed to some degree. We don't have a complete record here because I think Judge Barbas, and he even stated this, didn't think you could do this. He didn't think you could do it. He thought you can't really complain about your appointed attorney for ineffective assistance of counsel when you're dealing with ineffective assistance of counsel. So I think the court was mistaken in its application, but kind of just asked some generalized questions. So I fully admit that there was some generalized complaints. But to say that this was quote-unquote trial strategy, we had no testimony, no sworn testimony from Ms. Murray or even a full dialogue with her of what she was intending to do or not. So I don't think...
Well, I mean, I took that to mean trial strategy is often consisting of front-loading reversible error on the tail end.
Yes,
So I took it as one of those type strategies, not specifically for that trial, but the process, front-loading reversible error. I took it as an attorney or a client, more likely the client, trying to have the judge do something inadequate, but didn't provide enough detail for the judge to do something more adequate. That's how I look at the situation.
and in all fairness, this record is very skimpy. To say the least, we are not... It's very hard to say that Ms. Murray weighed different options. So when we get into that, if we wade into trial strategy as a way to say this is not, we're stuck because I don't have a way of saying yes it is or no it's not.
Right, you're doing the best you can. We really appreciate your candor, to be honest with you. You have about 2 minutes left. Do you want to keep going?
No, I will just make this brief argument. I think that this could have been cured if Judge Barbas had done a full, what's your problem with this? I don't find that that's a problem. Do you want to represent yourself? I'm fairly certain the way this was going that Mr. McEwan probably would have not wanted to represent himself. However...
Well, Mr. McEwan, the gist of his complaint was that his lawyer wasn't asking questions that he thought should be asked. That's really the sum total of it.
Correct, which could go either way in all fairness. It could go, hey, you're not doing it, let me do it, or can you just ask these questions and I'll just shut up and walk over here. So we don't know which one it would have been.
But it kind of begs the question, like, what more is the lawyer supposed to ask? When the lawyer asks Rees, if you had been called, are you going to recant your testimony? And Rees says, absolutely not, no way, no how. What's the lawyer supposed to do? Would you...
If it was me, I would stick to, as a trial attorney, I would stick to the strategy that I...
Would you turn to your client and say, sure, go ahead, ask a few questions?
I would weigh them. I mean, in all fairness to the court, I would weigh them. If they weren't absurd, I might ask a couple of them if they didn't tank what we were trying to do. But I don't know that I would go hook, line, and sinker in with some of the theories that some of my clients have come up with, in all fairness. But that being the case, I would ask that this court reverse and remand on Nelson and on Faretta, that a full hearing should have been conducted. Thank you.